Hi, everyone, and thanks for joining today's webinar on class actions. I'm Brian Fratkin, a partner in the McGuireWoods Richmond office, and I chair the firm's class action practice group. That mostly means I just get to go first. We have a lot to cover today on what happened in the world of class actions in 2021 and what we have to look forward to in 2022. This year we'll focus on the procedural developments in class action practice that should cut across all different types of practice areas. So we'll be focusing on standing, the Rule 23 requirements, settlement, attorney's fees, arbitration, and the like. So hopefully that means that regardless of your particular practice area, what we say today should be informative to your practice. I am joined by several of my colleagues in their Zoom offices. From Richmond is Trent Taylor, Brian Schmalzbach, and Drew Gann. And from sunny LA is Tanya Green. And I'll let each of them introduce themselves more fully when it's their turn to go. But I'm going to start. Before we do start, just a couple housekeeping items. CLE applications will be made on your behalf. Post-webinar, our CLE specialist, Juanita Price, will follow up with you regarding any missing information. Juanita Price's email address is jyprice@mcguirewoods.com. If you don't hear from her, you do not need a code, so you don't need to listen for that while we are presenting. We'll email you the slides from today's webinar after the presentation. And then finally, before we get going, if you have any questions, there should be a Q&A or some sort of chat box in your On24 presentation that you're looking at. So please feel free to type any questions in, and we'll be monitoring that as we go, and I'll do my best to answer them. We'll try to have a few minutes left at the end too, if there's time to answer any questions as well. So with that, let me start with a discussion on standing. We had an active year at the Supreme Court on standing. The two opinions came down, Uzabunam and then the TransUnion versus Ramirez case. The TransUnion case is a class action case. The Uzabunam case is a single plaintiff, but the holding there is relevant for class actions. And rather than go through, in any detail what each of those cases said, I thought I'd lay out the framework for how you think about plaintiffs and class members standing in federal court class actions. As many of you may know, the standing issue really took off with the Spokio decision in 2016, and then these two opinions in 2021 sort of solidified the Spokio standing decision. So what we all know from Spokio is that a plaintiff must plead and then ultimately prove concrete harm in order to have standing to bring a claim. Spokio said that, and then in the TransUnion case, Justice Kavanaugh applied that holding in Spokio to the class. So not only must the individual plaintiff or plaintiffs in a case show concrete harm, the entire class must be able to show some sort of concrete harm. There's a bunch of different ways to say it. Justice Kavanaugh said it sort of boringly: no concrete harm, no standing. Justice Scalia, in some publications, said it this way: what's it to you? I've heard no harm, no foul, of course. And then if a tree falls in a forest and no one's there, does it make a noise? Those are different ways to express that you can't bring a claim unless you have some sort of harm. The importance of that in class actions, of course, is that not only do claims that where plaintiffs and class members don't bring any allegations of harm can get dismissed early, but it also can bring into play some predominance problems when the injuries that the class does allege vary widely among class members. And as you know, in a lot of class actions, it's difficult for class members just to prove any injury at all. Another way that these cases help us analyze what actually constitutes class harm is as follows. So first, what we've learned from Spokio and then TransUnion is that a pure statutory violation with no common law analog is not a concrete harm. So a good example of this is what happened in the TransUnion case. Ramirez, the plaintiff, was among a group of class members who had incorrect information about his background listed on a terrorist watch list. That watch list, his background check, was shared with a third party, an auto dealer, and he went into the auto dealer, and the auto dealer ran a background check on him and saw that he was a suspected terrorist and would not sell him a car. So easy case for him to prove an injury. But the others in the class who were also on this terrorist watch list and incorrectly, they only had their names on the list, but that information wasn't published to others, so no car dealers involved with the other class members. And the court said that the publication, if it had been published to others, was enough to show concrete harm. But the others on the list whose information was not published and not shared with third parties did not have a claim, because there's no claim for just having bad stuff said about you if it's not disseminated. I'll go to the next slide. In this Lupia versus Metacritic case is similar in that there the plaintiff had a debt collector call her a day after she sent a letter to the debt collector that said she was represented by an attorney and disputed the debt. Now, it's hard for her to argue that any real harm based on one phone call, but the court in this case, in the Lupia case, said, well, your claim of receiving a phone call that was unlawful under the FDCPA is akin to a common law claim of intrusion upon seclusion, strange claim, but that's the common law claim. And so the court said, as long as there's a common law analog, a statutory violation alone by itself is sufficient. And then this Uzabunam case that I mentioned earlier, the Supreme Court case, said in a situation where there was a claim that the First Amendment rights were violated by a plaintiff who was trying to make religious speech at a college campus. He pleaded no actual damages, but the First Amendment claim at common law had a right to nominal damages, and so that was sufficient for standing. And then the last point I'll make on standing before I turn it over is what these cases clarify for us about the risk of future harm. So a plaintiff in a case may say, well, even though I'm not harmed right now, I might be in the future. And the courts on that point say, first, the risk of future harm is not good enough. The harm must be imminent, or the risk must have caused some other actual harm itself, like emotional distress. So in a situation where there's a data breach, for example, you have claims where there may not have been a threat of, or there may not have been an actual use of your stolen data, but as a plaintiff or a class member, you may say, well, my data I know was stolen, and it may get used by an identity thief down the road. And the courts have said, well, if it's not imminent and it didn't cause you some other kind of harm, like emotional distress, fearing about that, then that's not good enough to bring a claim. And then in the last case that I wanted to point out, the data breach case, the plaintiff said, well, okay, I have my data stolen. I'm worried about this, so I am going to cancel my credit cards. And as a result of canceling my credit cards, I've lost credit, I've lost the use of reward points and that sort of thing. And the court said, that doesn't work either. You can't manufacture your own harm. And that's this Captiva versus MVP Restaurants case in the 11th Circuit. So all in all, I think a good year for defendants who want a way to challenge class actions in federal courts at the earliest stage. It's much more difficult for a plaintiff to show and the class to show harm. I will leave with one caveat, though, which is that this is a federal court discussion, and this does not necessarily apply to state courts. So defendants who are successful in getting class action cases dismissed for lack of standing, depending on the jurisdiction you're in, California, for example, and others who have much more lenient standing requirements than in federal court, may find themselves in state court. So a small victory can win in federal court, but sometimes you face a bigger fight moving on to state court. With that, I'll turn it over to the other Brian to talk about jurisdiction.
Thanks very much, Brian, and good afternoon. Welcome to everyone who's joining us. My name is Brian Schmalzbach. I'm one of the co-chairs of the McGuireWoods Appeals and Issues team. I maintain a significant class action practice with a particular focus on some of the appellate issues that you see all the time in class action practice. And so Brian Fratkin talked about subject matter jurisdiction, Article 3 standing, and I want to continue to talk about jurisdiction, starting with personal jurisdiction. And this first case, which comes to us from the Ninth Circuit, addresses an unresolved question that the Supreme Court left open in the personal jurisdiction case, Bristol-Myers Squibb, from a few years ago, which is, what do you do in aggregate litigation when a named plaintiff or one plaintiff has a claim with good personal jurisdiction over a defendant, but included in the same lawsuit or adjoined to that lawsuit are other plaintiffs whose claims would not have good personal jurisdiction over the defendant, for example, because they're from other states. In Bristol-Myers Squibb, the Supreme Court said in a California mass litigation that you cannot aggregate claims to create personal jurisdiction over claims that wouldn't otherwise have it. So even though a California plaintiff might have good personal jurisdiction over the defendant, an Illinois plaintiff might not. And so that's good news, because this is potentially a very powerful defense in nationwide federal class actions, which we see all the time. The bad news is this case doesn't actually answer that question. We still don't know how Bristol-Myers Squibb applies to federal nationwide class actions, at least in the Ninth Circuit. And that's because the court addressed a separate issue and punted for the district court to answer the hard question about Bristol-Myers Squibb. And so this case came to the Ninth Circuit on a 23F appeal. And the district court had said that the defendant can't raise a personal jurisdiction objection as to the claim of absent class members because it had been waived, because the defendant didn't raise a motion to dismiss challenging the personal jurisdiction of absent class members. And the reason the defendant didn't do that is because the named plaintiff did have good personal jurisdiction. But the Ninth Circuit says that is not a good reason for ignoring personal jurisdiction objections after the class is certified. Because until the class is certified, those absent class members from other states, they're non-party. You couldn't raise a personal jurisdiction objection, so you had to wait until the class was certified. And so the Ninth Circuit reverses on the ground that that argument had not been waived and remands to let the district court figure out how Bristol-Myers Squibb actually applies here. So we'll have to wait a little bit longer to get some appellate clarity, at least in the Ninth Circuit, on how Bristol-Myers Squibb applies to federal class actions. Now I want to turn to address a question of subject matter jurisdiction, and in this case, the federal jurisdiction under the Class Action Fairness Act. The City of Fishers case is the class action on behalf of localities who claim that they are owed franchise fees, which are traditionally paid by cable providers, but the localities are suing non-traditional providers like Netflix and Hulu. The case was removed under the Class Action Fairness Act, but then remanded by the district court under something called the Comedy Abstention Doctrine. And I'll forgive you if you hadn't heard that before. I hadn't either. But that Comedy Abstention Doctrine is a judge-created rule that allows federal courts and requires federal courts to abstain from hearing claims over local revenue collection. since these franchise fees, cable franchise fees, are a form of local revenue collection, the district court remanded. The defendants appealed, and their argument was whatever the validity of the comity abstention doctrine in other cases, it shouldn't apply to a case that arises under the Class Action Fairness Act, because CAFA has explicit exceptions that we may talk about more later. And by enumerating those specific exceptions, Congress did not leave room for other federalism-style exceptions like the comity abstention doctrine. Now, the court doesn't give us a clear holding because it holds that waiver prevents the defendants from fully raising that argument on appeal, but it does show some real skepticism that CAFA eliminates these other abstention doctrines. It seems to think, the Seventh Circuit seems to think that it's perfectly fine to have judge-made abstention doctrines that apply at the same time that Congress laid out the conditions for abstaining under CAFA. And I think that should come as no real surprise to us, because judges probably don't want to hear local revenue collection cases, and the comity abstention doctrine gives them a good excuse for not doing so. And so with that, I will hand it over to my partner, Trent Taylor.
Actually, I think Tanya is going next.
Yes, I think that's
Sorry,
right. No problem. Thanks for that presentation, Brian. So my name is Tanya Green, and I'm in the Complex Commercial Litigation Department at McGuire. I defend a number of, as it relates to this presentation, I defend a number of consumer-related class actions, especially out here in California where I sit. So I have the pleasure of talking to you about predominance as well as numerosity. So hang in there with me because I've got the next two sections here. So let's see what happened last year in the world of Rule 23B predominance. And I apologize, I believe I'm on the right screen. Apparently I can't see, but I should be on the right screen, and you should see a slide for Olean as the first case. So that's a case out of the Ninth Circuit. It's a lawsuit that's been going on since 2015 in the Southern District of California. It's an antitrust multi-district litigation over the alleged price fixing of canned tuna. So that's a case where the trial court certified 3 buyer classes. So they certified the direct buyer retailers, the indirect buyer commercial food preparers, and the individual consumers, basically the end payers. So Starkist and the Bumblebee defendants appealed that class certification ruling to the Ninth Circuit. And in April of last year, the Ninth Circuit decertified those 3 classes. So a divided circuit panel ruled that statistical evidence can be used to establish who can claim an injury, but that first, the district court has to determine the number of uninjured proposed class members. So the reason that came up is because the tuna companies argued that the district court relied on regression models based on untrue assumptions that showed nearly all members of the classes were injured. So here you have the Ninth Circuit, of all circuits, essentially saying to the district court, go back because you've got a factual dispute to resolve here before you can grant certification. You need to figure out whether the statistical evidence included uninjured class members. And so why is this a predominance case? Of course, if a substantial number of the class members did not suffer injury, then the need to identify those members predominates. And if injury cannot be proven or disproven through common evidence, then obviously individual trials are going to be needed for that. So this case has some interesting subsequent history. A year after that ruling came out, the Ninth Circuit voted to vacate the panel's order and granted a rehearing. The Ninth Circuit just heard this issue en banc in September of last year, so we're still waiting on the decision. obviously don't know yet how this will play out. Maybe some of you have a good guess if you've ever litigated in the Ninth Circuit. But this case is certainly an example where a defendant was able to take advantage of errors in the plaintiff's regression models. So that is encouraging if you defend class actions in the Ninth Circuit. So the next case that we have, Russell versus Educational Commission for Foreign Medical Graduates. This case, we get to talk about issue certification, which excites me just a tad bit because it's just not something that I come across as often. So this is a case that's on appeal in the Third Circuit, Eastern District of Pennsylvania. This is a class of plaintiffs who claim that they were injured when they were treated by an unqualified, purportedly foreign-trained doctor. So they filed a lawsuit against the entity that was responsible for confirming the doctor's credentials. And they asked for class treatment of the issues of duty and breach. And so that in that case, the district court certified those issues. The defendant appealed, and the key issue raised on appeal is when is certification of an issue class appropriate? Last September, the Third Circuit found that the district court had abused its discretion. The court agreed an issue class can be certified. It's okay to do that even when the plaintiff's claim as a whole doesn't meet the standard for certification under Rule 23b3. But the Third Circuit's message to the district court is you still have to sufficiently analyze whether the issues of duty and breach satisfy Rule 23b3 requirements and whether there are common issues that have predominance. So, they basically followed the Third Circuit's Gates decision, and they found that the court should have analyzed, whether the effect certification of the issue would have, whether there would be an effect the issue class would, whether the effect certification of the issue class would have on the effectiveness and fairness of resolution of the remaining issues. And what they mean by that is basically they were saying the issue class is going to have to look at much of the same evidence as the individual class. The issue trial, the issue jury will have to look at some of the same evidence that the individual jury would have to look at. And that's because you still have, even if you certify duty and breach, you still have the other elements of the claims, such as, the cause, how much damage was caused, what the cause was to, what the role was that this entity had when they breached the duty, how much damage did that cause to the individual plaintiffs. So basically, they said where there's an overlap in the evidence, that's something to consider in terms of whether you're going to actually go forward and certify an issue class in this situation. So, and then they also criticized the district court because they determined that the district court didn't rigorously consider what efficiencies could be gained by resolving the certified issues. So that's just a reminder. I think, my read of the opinion is that the Third Circuit was signaling to that in light of the issues, an individual jury would still need to look at. There's an overlap in terms of the evidence that the issue class jury would need to examine. So that was the Russell case. The last two cases that, sorry, I'm still having a hard time seeing the slides here, but the last two cases that you should see up there are the Johannesson case and the Hudak cases. So these are both out of the Eighth Circuit, and they both deal with the application of the predominance factor when you have when it comes to fraudulent statements and the class members' reliance on those statements. So definitely a good time for class action defense attorneys in the Eighth Circuit if you have some facts that look similar to these cases. So I'll tell you what happened. The first case, Johannesson, is a case out of the district court in Minnesota, that was a class action against Polaris. And the named plaintiffs in that case claimed that Polaris failed to disclose to them heat defects in the ATVs that they purchased, and that therefore led them to pay more for the ATVs. The district court denied class certification because the putative classes included plaintiffs who did not suffer an injury, and also because questions involving individual members predominated over questions of law or fact common to the class. So basically what happened there is Polaris presented evidence challenging how much each consumer plaintiff relied on these alleged omissions. And in some instances, they were able to show that some members of the class were prior Polaris ATV owners who brought new ATVs despite their own earlier experiences with the alleged heat defect. And then to go further, a couple of those owners tried to sell their ATVs and described them as being in excellent condition with no mention of the heat defects. So the Eighth Circuit affirmed the trial court's decision to deny class certification in that case. So then the Hudak case, that came out exactly a month later, again, same circuit, Eighth Circuit, out of a district court in Minnesota. Very similar situation, class action against LG Electronics, Best Buy, and a couple of their subs. The named plaintiffs in that case alleged that the defendants had misrepresented the features of certain televisions that they purchased from the defendants. So specifically, they claimed that the defendants claimed the TVs had a higher refresh rate than they actually did. For those wondering, I had to look this up. I didn't know what it was. The higher the refresh rate is on a TV, the less blurriness you see in fast-moving scenes and the clearer the image is. So if you were wondering about materiality, that was why it mattered. Refresh rate is typically displayed on the product label, and the consumers claim that they relied on these allegedly false refresh rate labels, and they wouldn't have purchased the TVs or they would have paid less for them. So they proposed two different classes. In this case, the lower court granted class certification. The Eighth Circuit reversed. Once again, as in the prior case, the consumers did not see or rely on the allegedly false representations of assertions about the refresh rates for their TVs. There was evidence, and then there was also evidence that the refresh rate was immaterial in some purchases or to some consumers. So if you litigate consumer class actions a fair amount, then you know that this is an issue that oftentimes comes up, the issue of reliance on defendant statements and how plaintiffs have to prove it. And then you also have the issue of proving causations. And many times, either through the courts or through the legislature, there's a demonstrated effort to relax the traditional requirement for proving reliance on a fraudulent statement. And that was actually at play in this particular case because both the Minnesota and New Jersey legislatures some time ago had relaxed the standard for proving reliance. But nonetheless, you have here the Eighth Circuit holding firm that in both of these cases, even where the standard for proving reliance is relaxed, causation is still a necessary element of those consumer fraud claims, and defendants have a right to present evidence that causation issues create individualized issues. So with that, we'll turn to numerosity, and I hope I have the correct screen up, the correct slide up. If I do, you should see the Anderson case. Trent, if you can help me out and nod if you see the Anderson case up there. Okay, great. Again, I don't know why I can't see these slides. But let me manage your expectations here. So both of these cases have to do with class sizes just around 40 or under. And I'm flagging that now because I know a lot of you probably deal with classes that are much well into the thousands. So just want to manage your expectations. Anderson versus Weinert Enterprises, that's a case out of the Seventh Circuit. It came out of the Eastern District of Wisconsin. And it's a case where the Seventh Circuit spoke on the rule behind numerosity. Class has to be so numerous that joinder of all members is impracticable. I know a lot of times we get caught up on a specific number that has to be, that's the number where numerosity is met. This is a quote from the case. It says, though we have recognized that 40 class members will often be enough to satisfy numerosity, in no way is that number etched in stone. The controlling inquiry remains the practicability of joinder. So you have here a case where the court is willing to pull back the curtains and really explore other factors such as the nature of the action, the size of the individual claims, the location of the class members. In this particular case, the plaintiff was an employee of a local roofing company. He's bringing a dispute over how the employer was calculating overtime wages, and his proposed class included only about 37 members. And the court determined that joinder of those, the trial court determined that joinder of those members was not impracticable. And so these were the things that the court focused on. The fact that the plaintiff didn't identify any difficulty in locating or contacting potential class members. All but 2 of the potential class members lived within a 50-mile radius of each other, which meant that the class lacked the geographical spread that other courts have found as rendering joinder impracticable. And the district court also examined the awards available under Wisconsin law for these kinds of claims. And as it did that, it rejected plaintiff's argument that there wasn't enough incentive for an individual employee to sue. So basically, the court looked at the statute, said, hey, the statute includes recovery of attorney's fees and costs, and so that's going to offset some of the disincentive created by the small damages available if an individual wants to bring their own suit. So ultimately, the court found that joining a relatively small number of local plaintiffs was feasible. It denied class certification. Seventh Circuit affirmed this decision. And then the last case here in Ray Zetia antitrust litigation, that's out of the Fourth Circuit. It's an appeal from a district court for the Eastern District of Virginia. Again, another case exploring the impracticability of joinder in lieu of certifying a class. So very similar to the Anderson case, recognizing a lot of the language in the opinion is recognizing that there's no magic number. They said a class that encompasses less than 20 members will likely not be certified, while a class of 40 or more raises a presumption of impracticability of joinder based on numbers alone. But what they were really focused on in the facts of this case, they were focused on that gray area. They mean that what they meant is those cases between 20 and 40 class members. Those are the cases where the court said, we're going to look at all the circumstances of the case. They should all be taken into consideration when you're evaluating the impracticability of joinder. So just another case reminding the lower courts that they have to undertake the rigorous analysis of the numerosity requirement. In this particular case, they ultimately vacated the class certification ruling because the court failed to engage in that rigorous analysis when it certified a class of 35 purchasers. With that, I will turn it over to, is it Trent? Is it your turn or is it Brian?
No, it's Drew. It's Drew.
It's Drew, of course. Drew Gann, I apologize for that. I will turn it over to Drew Gann now.
No problem. Thank you, Tanya. Good afternoon, everyone. My name is Drew Gann, and I'm in the Products Environmental and Mass Tort Group. I've defended clients in class actions in a wide variety of industries, including product manufacturers, energy, and education. So 2021 was another year where a court of appeals weighed in on the administrative feasibility debate. In simple terms, the debate is whether there exists an applied prerequisite in Federal Rule 23 that the class administration be feasible. Courts that apply the administrative feasibility requirement want to ensure that the class is not amorphous or imprecise, making administrative difficult. Over the past 7 years, Court of Appeals has split on whether the heightened requirement of administrative feasibility even exists. The First, Third, and Fourth Circuits have concluded that administrative feasibility is a heightened requirement for class certification and must be considered. On the other hand, Second, Sixth, Seventh, Eighth, and Ninth Circuits have went the other way, finding that either a weaker or non-existent administrative feasibility requirement exists. In 2021, the 11th Circuit joined the latter group of Court of Appeals. In Cherry, plaintiffs brought a putative class action on behalf of purchasers of allegedly defective refrigerators. The proposed class consists of persons who purchased certain models of the refrigerators built all the way back in 1997. Plaintiffs contended that they had satisfied Rule 23's implicit ascertainability requirement by defining the class with objective criteria, and that Rule 23 did not require administrative feasibility. The defendants, on the other hand, argued, and the district court agreed, that plaintiffs failed to provide any evidence demonstrating a feasible method without overwhelming individualized inquiry to identify the putative class members, and thus denied class certification. On appeal, the 11th Circuit reversed and clarified that Rule 23's ascertainability requirement focused on class definition itself, not its administration. Thus, to meet the ascertainability requirement, the 11th Circuit stated that a plaintiff must demonstrate that the membership is capable of being determined. Further, the question of administrative feasibility addressed post-certification issues because a plaintiff proves administrative feasibility by explaining how the district court can locate the remainder of the class after certification. This analysis was better suited, according to the 11th Circuit, in analyzing manageability. And because manageability involves a balancing test, administrative feasibility could be considered, but was not required. So now, with almost all the Court of Appeals weighing in on the issue of administrative feasibility and what is clearly a circuit split at this time, the real issue we can see moving forward is whether this will become right for the Supreme Court and whether they will take it up to determine whether administrative feasibility is a requirement moving forward. With that being said, I'll turn it back over to Brian Smallsback for admissibility of evidence.
Thanks so much, Drew. This is another issue where there is a massive circuit split, and I expect that the Supreme Court will have to weigh in at some point pretty soon. They've already seen petitions in the space and haven't taken it up yet, but it is such a huge part of modern class action practice that they're going to have to weigh in. And the issue here is when you are providing evidentiary proof, when a plaintiff is providing evidentiary proof that the Rule 23 prerequisites are satisfied, does that evidentiary proof itself have to be admissible? In the Walmart v. Dukes case, the Supreme Court really strongly hints that yes, it does. And then later, the Supreme Court actually granted Comcast to answer this very question. And it turned out that they weren't able to answer that question in Comcast. They resolved Comcast slightly differently. But we're left with this big circuit split that keeps growing, including two courts just last year, 3 months apart, that came out different ways. So the first case was Prantle in the Fifth Circuit. This case addressed the literal fallout from explosions of volatile chemicals during Hurricane Harvey that spread over quite a wide region in Texas. And the Fifth Circuit held that if an expert's opinion would not be admissible at trial, it should not pave the way for certifying a proposed class. And the Fifth Circuit adopted that conclusion because of the significance of class certification in the life of a case. It's so significant, it drives settlement to such a great degree that the evidence ought to be admissible at that point. And the Fifth Circuit also says that it's implicit in what the Supreme Court has required in terms of a rigorous analysis, that the evidence used to satisfy that rigorous analysis has to be admissible. So when Comcast and Dukes talk about evidentiary proof, they are implicitly talking about admissible evidentiary proof. But different judges disagree. On the Sixth Circuit, in March, after Prantle was decided in January, it held that evidence does not have to be admissible to be considered at class certification. Lingas was a TCPA case where the plaintiff wanted to use unauthenticated evidence about who had actually received allegedly unlawful faxes to satisfy its evidentiary burden at class cert. But there's an important caveat in Lingas, which is that the Sixth Circuit says evidentiary proof does not need to be admissible, at least with respect to non-expert evidence. So there's this little open question remaining in the Sixth Circuit, whether the same lax rule would apply to expert testimony. In other words, the Sixth Circuit, it's not yet clear whether a full Drawbridge analysis has to take place at the class cert stage. And the reasons the Sixth Circuit give for this are very different from the Fifth Circuit's analysis. They say that class certification is supposed to occur at an early practicable time. And so because it occurs early, there's not necessarily time to develop the full range of admissible evidence that you would need at summary judgment, for example. And the Sixth Circuit also says that because class certification decisions are inherently tentative, we should give district courts the flexibility in allowing in evidence because they can always revisit it later. So we have that split. It appears to me that it's not going anywhere anytime soon. Lots of circuits have already weighed in. So keep an eye on the Supreme Court, which will ultimately resolve. And with that, I will pass it this time back to Trent.
All right. Thanks a lot, Brian. So I'm Trent Taylor. I am in the Richmond office. I do all class actions all of the time, or at least most of the time. A lot of consumer product work as well as some environmental contamination work. And I'm here to talk about two areas today, settlement and arbitration, but mostly settlement. And I'm going to start with class action settlements, which is the topic that everyone loves to hate until you are actually in a class action, and then it can be your salvation if you can get them approved. Now, that's a big if, especially lately, because the trend for the last few years has been that class actions are getting harder and harder to get approved. And that trend seemed to accelerate this year. I think we saw more and more courts scrutinizing class action settlements and rejecting them, or withholding preliminary approval more so than at any other point that I can recall. We're going to talk about a few such cases, and the first one I'm going to talk about here is the one up on screen, and it involves a long-running consumer class action against the makers of Wesson Oil. And so let me tell you a little bit about this particular settlement. So this settlement had a couple different features. First of all, it was a pure claims made settlement, and a pure claims made is not a fund. It's essentially where the defendant will pay out the claims as they go along. And here the actual compensation to the class was 15 cents per Wesson Oil bottle for each unit up to 30 units without proof of purchase. So that was the claim compensation aspect. A big feature of this was the injunctive relief. And the injunctive relief was to remove the label claim, which I believe was 100% natural here. That injunction or injunctive relief was valued by the parties, or more specifically by the plaintiff's expert, at $27 million. But the defendant had already stopped making that claim a couple years before, and it said that they stopped making it for some reason other than the litigation. And they had already sold the Wesson brand as well. And then the attorney's fee was based largely on that, the value of the injunctive relief, and was around $7 million, just south of that. So at the district court level, Ted Frank and one of his objectors, who's a law professor, that's the Henderson in the name of this case. It's not Florence Henderson, as you see below. It's actually the name of the Henderson, and the case name is the name of the objector. They objected. The trial court actually approved the settlement, and it went to the Ninth Circuit. And the Ninth Circuit reversed and just absolutely blasted both plaintiff's counsel and defendant's counsel in what was a pretty entertaining decision. And I want to talk about a couple aspects of that. First of all, you can see up here they said, we can perhaps sum up this case as how to lose a class action settlement in 10 ways. And it wasn't quite 10 ways, but there were 4 main things that the court flagged. First of all, that the attorney's fees were disproportionate to what the class received. Number 2, a clear sailing provision whereby the defendant would not challenge the class counsel fees. Number 3, and this was a big one, I think, was the injunctive relief that was touted as worth tens of millions of dollars appeared to be worthless, at least to the Ninth Circuit. And then a reverter clause. Now, this reverter clause is not the kind you see in fund type of class action settlements where you fund a settlement, and if it's not all used up, then some of it comes back to the defendant. This was actually a reverter clause on the attorney's fees. So the attorney's fees were reduced, any amount would go back to the defendant. So that's what the court flagged. And here are a couple of quotes from the, and as I mentioned, this was a pretty entertaining decision with lots of pop culture references and a good dose of snark. I think my favorite of these lines is the last one, where the court said, defendant thus essentially agreed not to do something over which it lacks the power to do. That is like George Lucas promising no more mediocre and schlocky Star Wars sequels shortly after selling the franchise to Disney. Such a promise would be illusory, as evident by Disney's production of The Last Jedi and The Rise of Skywalker. Ouch. On a number of different levels. So in any event, the case was remanded. The parties have already tried again, and it was rejected once again by the court. So I think they're trying for the 3rd or 4th time now, and we'll keep an eye on that to see what happens. All right. I want to talk about a few other examples as well, because that was not the only decision that sort of made some waves, especially in the Ninth Circuit this year, or last year, I should say. You have the Kim v. Allison case here that also reversed the approval of the class settlement. It found that the district court should have, scrutinized it more than he did, and it held that the attorney's fees should not have been based on the value of the injunctive relief without at least more scrutiny. And that's sort of the same issue that we saw in the Brasino case. So that's sort of an ongoing feature that I think folks who are involved in these settlements need to be particularly careful about, not basing the value of attorney's fees on the value of injunctive relief. Another case was the McKinney v. Drawbridge case. That was also a Ninth Circuit and also reversed the approval of the class settlement. You probably see a trend here, and it did it for 3 reasons. The attorney's fees were disproportionate due to the fact that vouchers should have been considered coupons. There was a clear sailing provision there as well, and there was also a reverter clause for attorney's fees. And then I also have another case here where Judge Alsop, he denied preliminary approval on a recent class settlement. And then I saw another one just this morning that I thought was particularly interesting. It was against the Five Guys, the burger joint. It was a wage and credit reporting class action, and it was a fairly modest settlement, $1.2 million class action settlement. And I saw that it's been submitted for preliminary approval 3 times, and the court has rejected it 3 times. So the bottom line here is that it's not easy to get class action settlements approved these days, especially not in the Ninth Circuit. Now, I want to talk briefly, very briefly, about incentive payments. This is a really fascinating issue that has been out there. I think it's something that most folks didn't really think about very much until about 18 months ago, when the 11th Circuit in the Johnson v. Impasse case reversed approval of a class action settlement, saying such incentive payments were barred by 2 U.S. Supreme Court decisions from the 1800s that apparently we've all overlooked for the last 150 years, except for Judge Newsom, who authored the decision. So we all missed it. Sorry about that, Judge Newsom. What's really particularly interesting is the impasse decision is still not resolved. It's still on possible en banc review and has been sitting for 15 months awaiting a decision on that, which has left a lot of federal district courts in the 11th Circuit in some limbo. And so they've been trying to figure out how to handle it. I've been involved in some 11th Circuit cases down there. And the way most courts seem to be handling it is simply to deposit the incentive payment into the court registry until this issue is resolved. But also what's interesting is the top case here, the Shane Group case in the Sixth Circuit, it actually held that incentive payments to named plaintiffs are in fact proper last year. So there's a circuit split here with the Johnson v. Impasse case on the appropriateness of incentive payments, and that's going to be something to watch going forward. A couple of class action settlement takeaways real quick. And I don't have very much time, so I'm going to wrap up here very quickly. Don't do clear sailing provisions if you can get away with it. Reverter clauses are sort of verboten in federal courts. Vouchers are fraught with peril. Don't base attorney's fees on the injunctive relief, as I mentioned earlier. One other thing I'll note real quick, pure claims made settlements are still viable, just not in the Ninth Circuit. And so, you know, it's something that, I guess the two real big takeaways are this. If you're going to do a class action settlement, you should expect an objector and expect close scrutiny, so plan accordingly. And second of all, if you're able to do a class action settlement in state court rather than federal court, that is something definitely to consider. Lastly, and I'm going to take 30 seconds on this real quick, arbitration, there were some very interesting developments. You can sort of look at these cases in your own time, but the bottom line is this. All three of these cases were wins for defendants wanting to enforce arbitration provision. And so it'll be interesting to see if that trend continues this year in 2022. So with that, I'm going to turn it back over to
Thank you, Trent. So given the time, I will just quickly cover bifurcation of discovery. Bifurcation of discovery and class actions has been a debated strategy amongst defense lawyers for some time now. And while this Santiago case that's on the screen did not deal directly with bifurcation, it does have important implications to its consideration. So in Santiago, the Seventh Circuit reversed the grant of class certification and remanded the case for further analysis. But critically, the Seventh Circuit reminded lower courts that the crux of any class certification inquiry begins with the elements of the underlying causes of action. And without knowing what exact claims had survived and what elements remained, the Seventh Circuit held that a court can never certify a class. So Santiago's analysis demonstrates that playing the longer game by filing both oppositions to class certification and a motion for summary judgment simultaneously could prove to be more effective. Because the summary judgment motion would allow the court to assess the merits of each claim, determine what claims survive, what elements exist before making a class certification decision. With that, I will turn it back over to Brian for the first 2022 things to watch.
All right, thanks, Drew. So I want to very quickly flag an order, not an opinion, but an order that came out of the Fifth Circuit in a big class action involving flight, alleged overcharges for flight. There's been very little appellate discussion of phased pending appeal and Rule 23F appeals. There's a lot of play in this in the district court, and these days are granted not infrequently, but the appellate courts just have not weighed in until the end of last year, when the Fifth Circuit, in actually a split decision, granted a stay of all discovering pending a Rule 23F appeal that had already been granted. And what the majority said is that they believed that the defendant, one of whom McGuireWoods represents, had shown a likelihood of success on the merit. The majority of the panel thought that there were substantial predominance concerns over the plaintiff's ability to show a class-wide damages model. The panel also noted that the costs of discovery in that case have been enormous and anticipated that they would continue to grow if the stay were not in place. And the real key to the opinion, I think, is a discussion of proportionality. And the gist of it is that if a class is decertified, if the Court of Appeals vacates the certification order, then you're going to be left on remand with only a handful of named plaintiffs, each pressing claims that are worth maybe $100. So not a very large total damage to that. And it would be disproportionate under the federal rules to allow millions and millions of dollars of discovery for claims that, amount to basically a hill of beans. And so it was a heartening order for class action defense counsel, because it does suggest that even if your district court refuses to stay discovery pending appeal, to stay merits discovery pending appeal, there's still a chance you can get relief from the Court of Appeals.
And next up on the Rule 23F front is the Ohio Public Employees case. So in 2017, the Supreme Court ruled in Microsoft versus Baker that federal courts of appeals lack jurisdiction to review an order denying class certification after the named plaintiffs have voluntarily dismissed their individual claims with prejudice. And in Ohio Public Employees, plaintiffs attempted to circumvent this decision. So after the Sixth Circuit denied plaintiffs' Rule 23F petition, plaintiffs requested the district court to sua sponte grant summary judgment for the defendant, which the district court complied with. And after the entry of summary judgment, plaintiffs appealed the case as a final order. On appeal, the defendants argued that the district court's sua sponte grant of summary judgment in their favor amounted to nothing more than a manufactured finality prohibited by Baker. And the Sixth Circuit panel disagreed. Specifically, the panel stated, it would be perverse indeed if we required a plaintiff to pursue a theory that she did not consider meritorious simply to preserve her right to appeal. But in dissent, Judge Griffith noted that this case is materially indistinguishable from Baker. While this may not be a big deal moving forward in a lot of cases, it is just a reminder that litigants, both plaintiffs and defendants, will continue to use different strategies to try to overcome authoritative case law when it exists.
So real quickly, I just want to do 30 seconds on class counsel fees real quick. There have been 2 cases on class counsel fees already in 2022, one from the 11th Circuit, one from the 5th Circuit. Both are good for defendant. It's basically more scrutiny on class counsel fees. One said no multipliers, and the 11th Circuit has had to tell the district court that twice now. No multipliers. And then the 5th Circuit one had to do with not awarding attorney's fees for unsuccessful theories, and in making sure the district court will actually scrutinize the settlement and take out the attorney's fees for the unsuccessful theory. So more scrutiny. We'll continue to watch that as we go forward.
And last but not least, there's a cert petition that we're monitoring here, which deals with CAFA's local controversy exception, which when certain requirements are satisfied, including that at least one defendant is a citizen of the forum state, and that defendant's conduct is a real basis for liability. If that's satisfied, then the district court is supposed to remand cases that are removed under CAFA. What's really going on in this case is just another example of plaintiffs attempting to use creative pleading to avoid CAFA removal. This case is one of a pretty common pattern that a plaintiff will allege corporate misconduct and then throw in a local subsidiary, a home state subsidiary, in addition to a national or international parent, without distinguishing between which of the defendants did what. And the plaintiff's position is that by throwing in the local subsidiary, that's enough to invoke the local controversy exception, which requires remand. So like previous cases where plaintiffs have tried to voluntarily limit their recovery to avoid the controversy requirement of CAFA, this is one where the Supreme Court may want to get involved to ensure that CAFA isn't being gamed by creative plaintiffs' counsel.
Thanks, Brian. It's Brian Fratkin again. We're just about finished. We had one question that just popped up that I thought I would read for the benefit of the group, and if others want to weigh in too, they can answer. But the question was, how many cases continue in state court for those that are dismissed for lack of Article 3 standing under Ramirez in federal court? And I don't have an exact number, but what I've seen mostly is threats by plaintiffs, class action lawyers, when they are faced with a dismissal motion in federal court for lack of standing. They'll threaten to refile in state court in order to get a settlement out of the defendant, either a class settlement or oftentimes, just a higher individual settlement. And then the other thing I've seen is just plaintiffs will affirmatively allege no injury when they file in state court so that they avoid removal by the defendant to federal court. If anyone else wants to weigh in on that, but that's my thought on that question.
Yeah, Brian, this is Brian Schmalzbeck. I've had a similar experience, and one of the things that we're really monitoring, and I think defense counsel need to pay attention to at the very beginning of the case, is what sort of state tolling rules apply. Because very often, by the time you get to a litigated Article III judgment, or certainly on appeal, a lot of time has come and gone. And so the question is, even if plaintiffs in theory could have filed the case back in state court at the beginning, can they go back now for cases filed in federal court? Can they go back now and file in state court? And there's a lot of state-specific tolling rules that need to be taken into account to determine what sort of jeopardy defendant is left in.
Yeah, a good point. You sort of have American pipe, but then there's issues if there's never jurisdiction in federal court in the first place, then, would the plaintiff or the class get the benefit of tolling? Well, that's about it on time. I just want to thank everybody for attending. If you have any specific questions, please feel free to reach out to any of us on the panel. We'd be happy to help. And otherwise, hope you have a good rest of the day. Thank you.